If anything, mail fraud's really cool. But it's really hard to prove. But what you can prove under RICO, well, actually, there's several things. One thing I'm going to talk about is a tortious malfeasance of a business relationship. It's a really nice name. I like it. It kind of rolls off the tongue. What it is, what happens when you go to a bank to open a bank account?
You have to sign papers.
Right, you sign a signature card, they start opening the account, then what do?
They give you papers.
No, they run check systems or some other company. Oh, I'm sorry, you can't have your account now. No, wait a minute, we already entered into a contract when I signed the signature card. And you're terminating it because of this. Who was the tortious malfeasance of the business relationship? Check systems. Check systems interfered with the business relationship of commerce between the two parties that were entering into commerce together. They accepted the funds, they took the check, you signed the signature card, therefore you have a contract to open the bank account. The tortious malfeasance of the business relationship was check systems. So somebody needs to sue check systems, right? How do you get a termination if somebody is doing something wrong or right? You have to sue them. Yeah. But you got to take it all the way to the Supreme Court to find out whether you're right or not. Okay, what's a first impression? Anybody know what first impression is?
In case they haven't heard particular facts.
Okay.
Patterns before.
Okay.
Principle.
If they've never heard it, how fast does the Supreme Court have to hear it?
Long time, right?
Immediately.
Oh, never heard it?
If they have never heard what you're saying before, they have to immediately hear it. Let's take a traffic case.
Talking about state Supreme Court.
State Supreme Court. If you take it before the state Supreme Court, or actually I should say, let's say this little building and codes thing down here cites you a building and code. You don't think the building and code is correct. You think that it's only for generating revenue. That's the only reason why they placed it there. So what you do is you take, they say, well, the judge goes, well, I'm ruling on you against this because this is the code. Then you could ask the judge one really simple question, and the judge is either going to say yes or no. Has this code been found to be constitutional or not, or is it merely for the generation of revenue? Now you ask that in a question, so he has to answer your question. What's he going to answer? He's either going to answer yes or no. If he answers no, I move for this case to be immediately dismissed because there's no grounds for you to be, no grounds. If he says yes, oh, I'm sorry, I have to do an interlocutorial appeal to the Supreme Court of the state to find out whether the code is constitutional or not. If it's not constitutional, then I have to go to the Supreme Court of the state to find out. If the Supreme Court of the state has already ruled that it is constitutional and I still don't agree with it, then I have to take it to the Supreme Court to find out whether the Supreme Court of the state has made a constitutional ruling that is within the confines of the state constitution and the Constitution of the United States. Because I want to make sure their interpretation is correct before I decide that I like it or not.
Well, you better have a lot of money.
Why? It costs you more than it does them.
Well, that's what I'm saying. I better have a lot of
No, it costs you more than them. For you to do it, it's cheaper than for them to do it.
Okay. Why?
Because to you, it's the time, well, I'll put it this way, it's the time that you put in to type it and the money it costs to file it against them.
Yeah.
And then whatever paperwork you file after that is the paperwork and research that you've done to file after that. So it costs you less than majority, probably about $5,000 to $10,000 to take it to the Supreme Court of the state. So, all the way up. But for them, along the way, it costs between $180,000 and $200,000 as it goes up.
So maybe you have money on your side. Maybe they don't want to fight it, right?
Well, some of them can't afford to fight it.
Yeah.
Some of them, the minute that they took it to the first case, they paid more than what they paid for the debt.
Yeah.
They paid the filing fee, which is $150, and they bought the debt for $5. if they bought the debt. I mean, the one question that everybody should ever ask if anybody ever sues them, how much did you pay for this debt? How much was it? They have to tell you how much they paid for the debt.
That's significant.
Fluctuations.
All of them. See, the original creditor is the original creditor letter in the information that you're getting today. The original creditor has there's a letter that you send them asking them for the original documentation that you have. The original application, the terms of the original agreement, all documents signed by you proving the amount of the obligation.
And wedding signature, right?
Well, it would be any sales slip that you signed.
Oh, okay, sales.
When you signed for that, when you charged it, you signed. If they don't have the receipts that you signed, there's no proof to back up the validation of the debt.
They just sent us statements.
Statements are not validation. That's the whole thing. But they destroy the signature things on the little receipts. They go to the warehouse in Arizona and the warehouse in Texas are the two places where those are shipped. They're processing centers. And they're destroyed after 24 months. Why? Equal Opportunity Act says how long to keep it? 25. So they decide, hey, we destroy it 24. We can wait a month. They're not going to know we destroyed it for a month. So we'll do the month sooner. So they destroy those records, so they're gone. So there's no way that they have to validate what the amount is that you charged on the card. Because you can't take an electronic file into the court record and have it testify. Yes?
Under Texas Rules of Evidence, Rule 107, optional completeness, if they produce one document, like the one you're talking about, you can demand that they produce all the supporting documents. And under Texas Rules of Evidence 901, you can ask for the authentic original documents, not best evidence or photo.
Yeah, if it was destroyed 48 months ago, and you had this card for 10 years, and now you're in your 60s or 70s, right in there, and you can't pay it because you've been paying on this thing for this long and it's still not getting down, right? So that by that time, all the original documentation's been destroyed. Yeah.
We were in a case where the judge stated that that was not required. If they didn't have it, they didn't have it, and went on with the proceeding of the collection. What do you do in a case like that? Just wait until you...
No, you sue them under the law of voids and you void the case.
And that's also included in the book?
Yeah, there's a section on the law of voids that is from Richard Cornsforth, who I'm one of his minions, I guess you'd say. He calls me up on the phone, and every once in a while he has somebody that needs some help, and he can't do it. He's been really busy. He's got a lot of stuff he's been working on. And he's been working on the same cases for a long time, but I mean, some of them are pretty amazing. But he's been a very good friend, and he started me off on all these seminars, and I've had a lot of fun. A lot of fun. And learned a lot, and expanded a lot, and found out information that nobody else has found. Including there's 6 reports. One is the fact that there's a report, a 1914 report, that states that all credit bureaus are immune from lawsuits.
Not told.
In 1914, there's a Columbia Law Review Journal study that all credit bureaus, mercantile agencies, are immune from suits from qualified privilege of immunity.
So you cannot sue a
It's,
credit bureau?
you cannot sue a credit bureau unless they do something that you can sue them for. You cannot sue them for defamation because they were found to be immune from that. And the reason why they said that they were immune from that was in the beginning, they figured that it would be too hard and too much of a burdensome upon the party that's creating the mercantile agency to go back and validate everything that he's getting from all these other different vendors because there's too many vendors that he's validating it from. They're sending him the documents and he doesn't have any control to figure out whether the document they're sending him is correct or not. So they wanted to relieve them of that ability to do that. The only exception to it is that if you can prove willful negligence to the credit bureau, then now whatever you want to sue them for applies. They willfully violate the Fair Credit Reporting Act the minute that you ask for a credit report, because they never give you the credit report.
They never gave it.
No, they never gave you a credit report. They gave you a piece of paper with a bunch of numbers on it. Do you know what all the numbers mean on the credit report? They divulge to you what the numbers are. There's collection agencies that are on it that their addresses don't work, their phone numbers don't work, but they're still on the credit report. If they get updated every 30 days, one group is on a 30-day cycle, one group's on a 60-day cycle, the third group's on a 90-day cycle. If they're getting updated 30, 60, 90,
They're not updated.
then why the report that you get should have all the addresses and phone numbers on the report should work, because it should be the current addresses that those companies are providing.
And you're not.
And if you write a letter to those credit bureaus and say, look, validate this debt because I don't think it, and I don't think this is correct, they have to validate it. If the information, you send out a letter to one of the collectors that they put on there and it comes back undelivered mail,
As addressed.
that proves willful negligence on the behalf of the credit bureau already, because they did not divulge all of the addresses of all of the people that you gave the information to, that they gave the information to, that you're asking for.
But what if they're out of business?
Now, if they're not in existence anymore, how can they validate the debt?
Okay.
Right? You're asking them to validate it, and if they're out of business and it's still on your report, even a better one. Because TransUnion they bought 5 companies. Pinger was one of them. What did TRW, before it became Experian, what did it do with those 5 databases? It merged them into theirs and didn't even validate the information to see if it was even correct.
Okay.
So now you got 5 different databases put into one, making it the worst database in the United States. The one that's supposed to have the most accurate credit report is Innovis, which is out of Idaho. Innovis is created by the Novus Bank, or Discover, the branch off of Discover, which is Novus, which is doing all the check cards for people. They've created the database and they're putting all the information into it, and it holds your it also is a medical bureau. So it holds medical information, it holds the data from your banks, it holds collection agencies, court records, federal records, prison records are all held in that cross-complaint into that database. Okay? The largest class action lawsuit against the credit bureaus started 2 years ago. Anybody see the ads in the paper?
No, I'm not aware of it.
Okay, it's in South Carolina. The judge ordered that it be turned into a class action lawsuit. Okay? The number one reason for the suit was that bankruptcy should not be shown on a credit report at all.
Really?
And they lost. Well, they didn't lose. The credit bureaus lost. So the judges turned it into a class action lawsuit, and everybody can get a sum of between $500 and $75,000.
Right now, it's ruled, it's settled.
That is they have to go out and publicize it in 34 papers, and they have to request. There's a line you get to request it and all the information that you want on it. They have to provide that to you. It's a South Carolina case.
Wow.
But if it's class action, it's for everybody.
Right.
It doesn't limit it.
Yeah. You can turn around. You can sue them tomorrow as you and all other similarly situated persons.
But that's only if you had a bankruptcy on your credit report, right?
Right.
Do you have the name of that case?
I do have the name of the case, but it's not available right now, but it will be. Yes.
I'm assuming that does this apply as well to, not necessarily credit credit bureaus, but, all these other companies out there that collect information on you, for instance.
Anybody that gathers any information and puts it in a database is a credit bureau.
Because insurance companies use other companies. that
Insurance
collect
is
data.
different. Insurance is different. It has its own statutes of why they cannot and when they can pull a credit report.
No, I'm not talking about a credit report. I'm talking about companies that keep data on you. In other words, they have all kinds of, they have,
Well, the biggest one is in Florida. That is the biggest. It's called the Medical Bureau of the. I forget what the name of the. It's basically the Medical Bureau, which holds all medical data on everybody, and it's in that database. You get in a car accident, the information goes to that place.
right, well, and this particular company, they collect that kind of data as well, but they also have your driving record and all of that kind of stuff. And so, does that, if they have.
Well, if you want to see,
information and
if
they
you want to
have
see something
information-
scary, go to nox.com.
NoX.com?
Yeah, knox.com.
What, but does it apply to them as well, is my question.
If they are
collecting data on you-
selling the data
Yes, they are.
to credit bureaus and banks, then they're a subscriber.
But it doesn't apply to insurance companies?
No. Insurance companies is a whole different set of sections of guidelines and laws that you have to abide by.
Okay, but I'm not talking about the insurance company.
I know, you
I'm
just
talking
said,
about
well,
the company
the,
that
if the
collects
company
data.
that collects the data,
Uh-huh.
if it gives it to an insurance company, other guidelines apply. If it gives it to the credit bureaus, they're a subscriber, and there isn't any.
Okay,
Unless the subscriber provides information that's false to the credit bureaus. Then they become a co-conspirator of the information, meaning a co-generator, which makes them liable and the credit bureau liable for a torturous malfeasance of a business relationship that you had with whoever you were trying to get the credit from.
okay.
Because if they provide the information to the credit bureau and the information's false, and you lose something because of that false information, and then you end up proving that that information's false, now that, even though the credit bureau was we're just relying on what they give us. But they're liable. And how is a credit bureau liable for that information?
Well,
They sell the report, making it a newspaper.
okay.
Once they sell the report to some other party, they're selling it to a third party that has no other interest other than the contractual interest that they have to provide information to them and pull reports. But they pay to pull those reports. Does anybody have the time?
10, 12.
I got all day long.
10:15? Okay. That,
I got a question on that. If you do your credit report and you find that there is a bankruptcy on the credit report.
Right.
That bankruptcy on that credit report destroys your chances to, say, refinance your home, for example.
well, that was the whole gist of the
Where would
guy's
be the
lawsuit.
recovery?
That
Where
was-
would be the recovery there? What could you request?
Well, if what could you request? It would be the damage that you lost.
And who would you file it
Like,
against?
like for instance, there's a group of people that they were applying for a house. You got the house. You got the house. It's okay. We got the house. Got your financing. Got your financing. Go find your house. Right? They got pre-approved for the mortgage before they went and looked for the home. They looked for the home. Oh, all of a sudden there's a problem. Well, I mean, how was there a problem? Information got on their file that wasn't theirs, that isn't theirs. It's identity theft. And what happened is they're changing everything on the loan, which made them lose the house. So their loss value is the $148,000 home they were going to try to buy,
Okay.
because they lost the ability to buy the home because of what happened on the report. So they all interconnect together. And there's a really cool thing. Everybody's heard of the new Medicaid Act or prescription? You know, within the Medicaid Prescription Act, there's a reference to the credit bureaus. There's an amendment. No. The amendment is that there are certain steps that all county district attorneys are supposed to do before they put child support on a credit report. And it lists what they're supposed to do.
And they
If they don't do any of those 4 things, or that list that they're supposed to do, that reference to the child support or the amount of money that they owe on the child support has to be removed from the credit report. And the district attorney in the county that placed it there not filing the steps is liable for it. Because what would happen is instead they have to give a letter of notice that you owe the money for child support, back child support. They have to give you a notice before they report it to the credit bureaus. The district attorneys are never sending the notice to the people to inform them that they owe it, to give them the time to correct the amount that they have before it goes on to the credit report. They never send the notice out. Why should we send the notice? He's a deadbeat. He doesn't need his rights protected. What happens if you don't sue? Let's see. What happens if something comes up and you decide not to sue the party for it?
Well, don't you just give up your...
You give up all your constitutional rights if you don't sue them. If you heard Chief Justice of the Supreme Court, Rehnquist, stated, everybody is in jail by their own admission,
It's probably true.
is why they're in jail. Okay? You know that if you were charged anything criminal, there's not a court in the United States that could convict you of it, even if it was murder?
What?
All you have to do is ask one simple question. Your Honor, I really don't know how I'm supposed to plead right now. I don't really have a clue how I'm supposed to plead. Well, then what's the court going to do? The court's going to enter a plea of not guilty for you. The minute they entered a plea of not guilty for you, you ask, is that for the record, Your Honor? Yeah, I'm stating it on the record for you. Don't worry about it. You can go find your help that you need to be. I just put it on the record as you're not guilty. You walk out of court, go over to the federal court, file a civil rights lawsuit against the county and the judge had just entered the plea of not guilty for you. Because he violated your Fifth Amendment rights, your Sixth Amendment rights for due process and assistance of counsel. There was no assistance of counsel when he entered the plea of not guilty. So you had no advisement as to whether he could do it or not. So because they violated your civil rights, it didn't matter what you did, you just got off.